Hi, everyone. I'm Rachel Thompson, National Director of Development with HSC. Welcome to today's session on estate planning with our panel, Rebecca Little, Vern Barrett, and Zach Bronstein, who will be joining us by a pre-recorded video. The session will explore the different facets of transferring power of attorney and preparing your estate, including how to set up your estate goals and ensure the family's wishes are upheld. We will discuss maximizing tax benefits through charitable donations and taking advantage of different tax incentives. From the community member viewpoint, we'll review how to come to the personal decision of transferring power of attorney, what the process is like, and how to prepare your loved one for these changes. And now I'd like to introduce the panel. Rebecca is an associate lawyer at KW Law and Madoran Snyder LLP, who works with the corporate, commercial, real estate, and wills and estates group. Before joining as an associate after her call to the bar in 2020, Rebecca completed her articles at Madoran Snyder LLP, where she was able to gain experience in a wide range of practice areas. Rebecca earned a Bachelor of Knowledge Integration at the University of Waterloo before earning her law degree at Western University. She was actively involved in student politics at both institutions, and her involvement included acting as chair of the board of directors for the university's Students' Council at Western and as elections chair for the Student Legal Society. Rebecca was born and raised in Bruce County and currently lives in Kitchener, and in her spare time, she enjoys reading books, visiting the cottage, and textile arts. Vern Barrett represents a community member aspect of this panel. Many of you might know Vern, and he and his wife Ellen have been involved with HSC since its inception over 49 years ago. Vern continues to serve as president of the Manitoba chapter. He has also served 10 years on the HSC National Board and 4 years as its chair. In his other life, Vern had a lengthy career as an educator at the public school, government, and university levels. Zach is a senior tax manager in the enterprise tax practice at KPMG LLP out of the Waterloo office, where he advises clients with respect to all matters of domestic income tax planning with a focus on estate tax planning and acquisition tax planning to optimize his clients' tax results. He was admitted to membership as a chartered accountant, chartered professional accountant in 2014, and has been practicing tax since 2011. During his career, he has worked with various mid-size and Big Four accounting firms, as well as in the industry. This multidisciplinary panel is sure to engage us on how to make estate planning and power of attorney decisions stress-free and informed. And now I will turn it over to Rebecca Little, who will start our presentation.
Great, thanks. I'm going to go ahead and share my screen. Give me a second here, guys. Go. There we go. All right, so I'm going to give you sort of a quick overview to planning your estate. It's emphasis on quick here. I'm going to try to run through sort of the broad vision. You'll have time at the end for some questions. I'll be around if you have questions, happy to answer them. But hopefully this gives you an idea sort of where to start. My name is Rebecca Little. As Rachel said, I'm a lawyer. A couple caveats to that. I'm a lawyer, not your lawyer. I'm going to give you some legal information, some legal advice, but you're always best to get advice from a lawyer who knows your specific situation. And also, I'm an Ontario lawyer. If you're tuning in from somewhere else in the country, it might not be applicable. I've tried to keep it as broad as possible, but again, always best to check with a lawyer in your own province. First thing is I'm going to talk about a couple of definitions here, just so we're on the same page. So when somebody dies, any assets that they owned are automatically not owned by them anymore. And sometimes those assets will go out directly to a survivor. So for instance, if you own a house with a spouse, often by right of survivorship, it'll go directly to them. But anything else that you own, so think bank accounts, investments, any cars, any other properties that are not held jointly, goes into your estate. The will is a document that you can create while you're still alive that names a person to be in charge of that estate. That person is an executor or an estate trustee. I use the terms interchangeably. And the will can also have instructions to your estate trustee on how you want your assets in your estate handled. And anybody who receives a benefit from that would be a beneficiary. Power of attorney, on the other hand, sometimes these are called living wills. The idea here is it's a document you create while you're alive and have capacity to grant somebody else the authority to make decisions when you're not able. The person who's named there is called an attorney. I know we all watch American legal shows and you see them called an attorney. In Canada, a lawyer is typically not called that. An attorney refers to that person that you've nominated in that document. There's two broad kinds: a power of attorney for personal care. So that's a person who's going to be making medical care decisions. And that power of attorney typically doesn't kick in until a doctor says this person isn't able to make decisions. And, if you regain capacity, you can still make your own decisions. And it just is for whenever a doctor says you're not able to. A power of attorney for property, on the other hand, deals with any sort of property. So real property, assets, cash, investments, anything like that. And that document can actually be used even while you still have capacity. So for instance, sometimes you see this when somebody is on vacation in another country for a couple months and the bank needs somebody to show up. They can send their power of attorney. You don't have to be incapacitated to use it. So that's what a power of attorney is. Now, the next thing is everybody should have a will. Now, obviously, we are here because you all are affected by Huntington's disease in some way, or a loved one is. But this is advice I give everybody. I talk about it at parties. I'm a lot of fun at parties. Everybody should have a will. It's an important document to have. If you don't have a will, it becomes a lot more expensive and a lot harder on your loved ones to deal with after you've passed away. Your actual assets are going to be distributed per what we call intestacy rules, which vary by province and might be what you want to happen. They might not be what you want to happen. In some provinces, including Ontario, if you have, for instance, a partner that you're not married to, they are not automatically entitled to anything. And they then have to bring an application, which again is more money. So get a will. It's a good thing to have. I'm going to go next to everybody should have a power of attorney. I think even if you don't have a will, consider getting a power of attorney. I know sometimes with a will, there's a bit of a psychological block to not wanting to think about, what happens when you die. But a power of attorney, I think, is in some ways more important, because when you don't have a will, it's kind of a mess. It takes more time, it's more expensive, but you have sort of the time to deal with it. With a power of attorney, if you have a stroke one day, or you get run over by a car and you're still alive, you're in a coma, there's immediate things that have to happen, and courts aren't immediate. So somebody has to apply to become a guardian of the person or a guardian of the property in order to get that figured out. And that takes a lot of time. And so I always encourage people to get a power of attorney. And as I say, there's the two kinds, the one for personal care and the one for property. You don't have to name the same person if you don't want. Often people do, but that's up to you. I'm already running low on time, so I'm just going to give you a couple of practical tips. As I say, I'm here for questions afterwards if you have anything specific. I want to talk a little bit about choosing attorneys and executors. So you want to choose people that you trust, obviously. I don't recommend, naming a bunch of different people, right? If you have 5 kids, don't name all 5. You need to think too about their skill sets. They're going to be required to, take on accounting for you to make sure everything is done correctly. They're going to have to probably talk to a lawyer about stuff. For the medical one in particular, think about who's around and who's aware of your particular circumstances. You probably don't want to name somebody that's going to have to drive a couple hours to the hospital every time they need to use it. So things like that you should be thinking about. The next thing is the states have obligations. So this is particularly in thinking about if you have a loved one that has Huntington's. If you've been providing financial or other support during your lifetime, you should make sure you have something in the will that allows them to continue to receive that kind of support. If you don't, they can have what's called a dependence relief claim that allows them to make a claim against the estate. The idea basically being, if you've been supporting them, they're entitled to some amount of support going forward. If you're in that situation, I'd highly recommend talking to a lawyer about that. Next one is the best interest of your beneficiaries. Again, if you have a loved one that has Huntington's, if they're on some sort of disability support payment, if you give them a bunch of money, that might kick them off of that system. There are ways around that. If you're in that situation, talk to a lawyer. It's a little bit complicated. You have to create a trust, basically, but it is worth it because if somebody gets kicked off of those benefits, even if you're giving them a significant amount of money, what happens after they run through that money? It takes time to get back on benefits. And the other thing is the healthcare that comes with it. So the healthcare plan and the prescription plan, they will lose as well. Storing your documents, this is just a really practical. Make sure that the people that you do name as the attorneys and executors know where your documents are. Sometimes they don't, and that becomes a big issue. Medical directives. So in your power of attorney for personal care, you can put any sort of direction you want. And I know that people who deal more with the medical system often have opinions on what sort of treatments they want. So the most common you see is the do not resuscitate or don't artificially extend my life. But you can add all sorts of different things. If there's specific drugs you don't want to have, if there's specific kinds of treatments you don't want to have, consider putting them in. If you don't have them, it's okay. The attorneys just get to make the decision. And you can also always have conversations with them about, what you want. And I encourage you to do so. All of these things are always better. If you have attorneys and executors, you can talk to about these things because they should know. Avoiding tax isn't the purpose of estate planning. You're going to hear from a tax accountant. It's helpful things to know. But sometimes people get really caught up on how much tax their estate's going to have to pay. It's probably less than you think. And it's more important that your estate is done to your wishes than it is perfectly optimized for taxes. And the last one is updating your will and POAs. So we say the last will and testament, but it's not your final will and testament, right? It's the latest one. So you should be thinking about updating it every time sort of a major life change happens. Generally, they're written to sort of future-proof things a little bit, like all of my then living children kind of thing. So if you have more children, they get included. But think about when it makes sense to update it, and keeping on top of that is it's important, right? I see wills sometimes from the 1970s, and it's better than having no will. But the law changes, your circumstances change. So I encourage you, if you are out there and you already have one, to consider updating it. And if you do get one, to sort of put it on your radar for 5 to 10 years from then, check back. Is it still relevant? So that's what I wanted to cover. Thanks for listening. As I say, I'll be here for questions, and hopefully that kind of covered the basics for you. Well, stop sharing my screen.
Hi, everyone. My name is Zach Bronstein. I'm a senior tax manager at the KPMG Kitchener office. I was asked by Rachel Thompson with the Huntington Society of Canada to deliver a recorded presentation for you today. I understand that you'll be joining via conference. I can't be with you there live today, so hopefully this presentation is useful to a broader discussion, and I hope I can contribute in terms of a general overview of what I'm going to be discussing today, which is charitable gifting in the context of estate gifts. So with that, we're going to dive right into the presentation. The first aspect that I want to discuss is in terms of compliance as it relates to estate taxes. So the first key tax filing that an executor or trustee in the context of an estate needs to bear in mind would be the filing of the terminal tax return. So that would be due for filing the later of April 30th of the year following the death of the testator and 6 months after death. There's also an estate return that needs to be filed. The initial year end cannot end later than the anniversary of the date of death, and the return is due 90 days after the estate year end. Now, CRA can take quite some time to assess, and so there's not much that can be done for purposes of rushing them. They operate pursuant to the whatever returns that they have in their queue at the time. So sometimes this can take upwards of 6 months, and so really, as we work through the rest of the timelines, what is really an important takeaway is to understand that the overall wrap up of all the compliance for the estate can take some time. And while this is taking time, the timing of the donations needs to be managed to ensure it can be utilized either on the terminal return or on a return for a graduated rate estate, which we're going to discuss subsequently. So the key theme you're going to see is CRA can take their time, and estates are not quickly administered from beginning to end. And so that's just a reality that all executors need to be aware of and be prepared for. Another area of interest in terms of overall tax compliance to an executor is oftentimes obtaining a clearance certificate from CRA that basically certifies that the estate is caught up on all its tax filings and has no outstanding tax liabilities due, which oftentimes gives executors peace of mind for purposes of making a final distribution if there's an area of risk around that for purposes of the estate's administration. So one important thing to keep in mind is a clearance certificate cannot be requested until the final estate return to the date of windup is assessed. And then the executors must wait for notices of reassessment for the terminal return and estate returns. And CRA's standard timing to process is 120 days for simple estates and longer for complex estates. So we're going to look at what that means in terms of timing from beginning to end next. So depending upon the date of death, it could be 2 years or more before a clearance certificate is received from the CRA. And so here's a quick example we'll walk through. Suppose an individual passes away March 31st, 2023. The terminal tax return would be due to be filed by April 30th of 2024. The initial year end of the estate, if the anniversary date of death is March 31st, the estate would then that would mark the anniversary date for the estate's year end, and the return would be due 90 days thereafter. So the estate's first taxation year would be due to be filed in late June. So that's the June 29th date. Assuming CRA takes 6 months to assess the estate return, which would take the timeline down to December 2024. At that point, a clearance request package could be submitted to CRA in early 2025. And then, as we discussed earlier, CRA would take 4 months if the estate is simple enough to issue clearance. And so even in a very simple estate where an individual has passed away March 31st, 2023, clearance certificate at best is going to be received in sometime in the summer of 2025. And so that's 2.5 years of estate administration for the most basic estate example, where the estate can be administered within 1 year and only requires one taxation year for purposes of administering, making the bequests, making the distributions, and winding up. And so where multiple taxation years are required of the estate, that timeline can continue to extend. So why is that important for purposes of the broader discussion that we're having today around charitable bequests or estate gifts? The reason being is that timing is so critical for purposes of ensuring that the donations can themselves be utilized either on the terminal tax return or on a return for the graduated rate estate. And so some important considerations for the group here is that there's a 60-month deadline to make that donation in order to be able to either claim the donation on the terminal tax return, which would offset most of the taxes due to a deemed disposition at death, a year, the year immediately preceding the year of death for the individual, or in the first 3 years of the estate. So those 60 months, as we saw, those can quickly approach if you're exclusively just looking at the compliance part of it. So while the compliance is underway, the donation still needs to be very much dealt with to ensure that that 60-month deadline is satisfied. It's also important to understand some of the requirements around the donation itself in terms of what needs to be done in order for the donation to be claimable on a tax return. And so prior to 2016, donations were deemed to be made immediately prior to death. However, there were legislative changes introduced effective January 1st, 2016, such that donations are not considered made until the actual payment to the charity is made. So we're going to look into that in more detail. But as a rule of thumb, the donation needs to be made before the credit can be claimed, which is just a newer tax rules under the 2016 legislation that I mentioned. So that adds complexities in some cases where the estate has residual charitable beneficiaries, and we're going to discuss that as well. So as a general rule, donations need to be made before they can be claimed. There is an administrative policy that CRA has put forward, just acknowledging the challenges that may have on some estates, where CRA will allow a donation to be claimed, provided that the executor submit the will of the testator, submits to CRA a letter that was sent to the charity advising of the gift, in which the amount of the gift needs to be clearly stated. There needs to be an acknowledgement letter back from the charity stating that they will accept the gift. And there needs to be a letter from the executor regarding the GRE status, so the graduated rate estate, GRE status, for the estate itself. So this can be met in order to satisfy the administrative policy that CRA has put forward. However, there's a few criteria that may or may not be challenging in the circumstances, and we're going to look at some examples where satisfying that criteria could be a challenge for executors in some of the following examples. Before we do so, it's important for everyone in today's conference and listening to the presentation to understand how the gifting of capital properties works out of an estate. So if someone has shares of a company that they're seeking to gift, or artwork that has appreciated in value, or potentially real estate property that they're seeking to give to a charitable organization, there's a few taxation implications to that executors need to understand. The first being is that there's a deemed disposition at fair market value of that property at the date of death. So whatever the property is worth, there's a deemed disposition at that fair market value at the date of death, simply by virtue of the testator holding that property at death. There is also a deemed disposition at the updated fair market value at the date of the gift. And so because there's two deemed disposition dates, any fluctuation in the fair market value from the time of death to the time of the gift can potentially cause some issues. The first is where the fair market value is increased from the date of the death to the date of the gift. And so where there's an increase, there's a capital gain. Fortunately, the donation credit provisions allow that capital gain to be fully sheltered with the donation tax credit. Where there's a decrease in value, there's a capital loss. And so whether that capital loss has been realized in the estate's first taxation year would make it utilizable on the terminal return, meaning that the executors can file an election to have that capital loss carried back and reduce some of the taxes at death that way. Since there's a deemed disposition both at death and fair market value, valuation fluctuations need to be managed, and so that's where disposing of the property on a timely basis after death is oftentimes one of the best ways to mitigate and hedge that risk of fluctuation. So now that we understand a bit about the deadlines for filing the tax returns and some of the timing requirements for purposes of making the donations and some of the criteria for CRA's administrative policy in order for that donation to be claimable, hopefully what is becoming clear to the audience is that timing is everything for making these donations. And so the sooner the donation can be made, the better assurance there is that the donation can be claimed on the terminal return or the graduated rate estates tax return. And so next I want to talk about just a very easy, quick, commonly understood way for making a donation, and that's through naming a charity as a direct beneficiary designation on a life insurance policy or registered plan. Donations occur quickly. Oftentimes they occur even outside the estate themselves. They're not subject to estate administration tax, and because of the direct beneficiary designation, it's considered to be made by the estate immediately after death. And so that satisfies a lot of the concern around meeting that 60-month deadline that could otherwise be concerning for executors. So direct beneficiary designations is an important tool in the toolbox for making timely donations. So we talked a little bit earlier about some of the situations that could contribute to a donation being delayed in terms of the ability to determine it and make it. And one common such example of that is a case where there's residual beneficiaries. And so for those who aren't familiar, an example of a residual beneficiary is a case where in a testator's will, they've identified that they want, say, 10% of their estate to go to a registered charity. So let's say United Way or Sick Kids. So because they've expressed that donation as a percentage of the estate residue, it makes them a residual beneficiary. The contrast to a residual beneficiary is a beneficiary of fixed amount. So a fixed amount beneficiary would be like saying in the will that $1 million is to go to United Way, which simplifies matters in estate administration than saying I want 10% of my estate to go to United Way. So fixed amount bequests are a lot easier to determine, to calculate, and because they're easier to determine and calculate, they're easier to pay. And because they're easier to pay, it makes it more likely that the deadline can be met, so that the estate would remain a GRE when it's paid. So that's a bit about residual beneficiaries. As I mentioned, the computation of the residual value becomes difficult to quantify and manage. One of the reasons it becomes difficult to quantify and manage is because the donation itself is subject to a donation tax credit, which can give rise to a refund of taxes otherwise payable on the terminal return. So if you can just kind of think about this, if a testator is bequesting an amount to a charity and he's saying, I want it to be 10% of my estate residue. Well, if sort of an initial amount is estimated to equal 10% of the residue, not paying mind to income tax refunds, well, when that donation is made, a donation credit is issued, a refund of taxes is obtained, and now the estate has come upon more cash by virtue of the tax refund that again forms part of the estate again, 10% of which needs to be paid to the residual charitable beneficiary, and so the calculation starts over again. So it can be a very iterative process. Sometimes it can be solved with some advanced mathematics to determine what is the final amount that will ultimately be paid through the different iterations to the residual beneficiary. but that's only where simplifying assumptions are made, and sometimes an estate might be complicated enough such that that's not readily determinable. And so one of the criteria we should remember under CRA's administrative policy is that the donation amount needs to be readily determinable, because it's what's being notified to the charity in the letter that needs to be written to the charity and submitted to CRA as proof of the donation that would be forthcoming. So residual beneficiaries, it's a cautionary tale. Some testators have them, and I've seen it in practice where it can add complexity. So beware of them to the extent that estate planning can be undertaken before someone makes a charitable bequest. It is advisable that they remove charitable residual beneficiaries from their will and instead make them fixed amount beneficiaries in order to address this complexity that I've raised to the group. So with that, that marks the end of my presentation. Hopefully this gives a quick overview of some of the issues and considerations that executors need to have for purposes of administering the charitable bequest in an estate. I want to thank everyone with the Huntington Society of Canada for letting me present to your audience today at your conference. Again, it's regrettable I couldn't be with you today, but hopefully this presentation was helpful in discussing some of these issues. And with that, I'm going to turn it over to the other speakers, and I wish you all a fantastic rest of your day. Thank you very much. Bye.
Hello, folks. My name is Vern Barrett. I'm a longtime volunteer with the Huntington Society, so probably if I knew who you were, I'd be shaking your hand a few times over the years. My wife Ellen and I have been volunteers for 49 plus years. She was on the original board of the Huntington Society, and you were watching Ariel Walker's comments before about their camping trip to Western Canada. Yeah, they came here with their camper. The kids rode our bikes, and we connected with people that really made a difference to Huntington Society. So we've been at this for a long time. My wife Ellen is currently afflicted by Huntington's. She's still able to walk around, fortunately, but I am her caregiver. And so she had late onset. So I want to kind of outline how we approached wills and designating power of attorney and how we navigated the process, because it may be similar or slightly different from what you are going through, but perhaps what I share will be useful. We have both, Ellen and I, had the experience of having people die without a will early in our lives. And we saw the difficulty, the unrest, the problems with family and so on in terms of dealing with that. And we were determined to do what we could to prevent the problems for our family. So we have always had a will from the time we were married, even the simple handwritten holograph will, which is legal. But you know, you fill it in, and it's kind of a will in a kit, and you don't even have to have it witnessed if it's written in your own hand, and it's better than no will at all. And so we progressed after that to meeting with a lawyer to make basic wills. As a young married couple, like many of you, if you share our situation, or perhaps not yet, or maybe never, we were broke, trying to establish careers, had some thought of wills, maybe our handwritten one. Certainly didn't have any idea what a POA was, or why power of attorney, or why we would need one at that point. And we certainly weren't planning our estate. We didn't have one. So then with a young married couple with young children, which came quickly for us, we were still broke. And concerns about who looks after the kids if we're both gone actually got us to draw up a will, because you want to have at least some say, hopefully, in guardianship of the kids, just in case you happen to both get hit by a truck or something like this. So we went to basic wills with child caring preferences indicated, and used godparents in those days to hopefully get some sway with some people to pick up where we left off with the kids. But again, the courts would have decided. Then we were a married couple with teenagers. Well, and depending on the day, we'd wonder if anybody wanted to look after our kids. But nevertheless, we were still broke and getting broker raising teenagers. But of course, we were trying to save for kids' education, and we were concerned about the future. And basically, at that point, we're looking at more advanced wills. So we were using legal services, community mall legal services, and not free, but not really expensive. We didn't have much estate planning in it. We certainly didn't have a power of attorney at that point. And then we were a married couple with adult children. In the case of Ellen's Huntington's, it was late onset, so she was retiring. And the adult children were either in college or had left the house. And so at that point, we were looking at an advanced will, in our view, with some estate planning and perhaps a power of attorney for both of us. Looks like I've lost the video feed. I'll keep going, Rachel. I don't know if you can fix that. And then when we were a Huntington, there we go. Well, there should be no reason for this. There we go. When we were a married couple, one with HD dealing with cognitive issues. So there we are. It had advanced to the point where I had actually been able to get a caregiving benefit from the government, designating me as a caregiver for Ellen and receiving a tax credit for that. And so with that in mind, then you have some basis, I suppose, maybe not legal, but other, for making decisions on one's behalf on a regular basis. And so we had advanced wills drawn up, we had bequests, and at that point, we also did power of attorney for both of us. Why both of us? Well, first of all, it's more inclusive. It does make the person whose needs perhaps is going to die faster or need a power of attorney faster. It doesn't make them feel like they're out the door, so to speak. And it certainly doesn't negate the idea of somebody getting a stroke or being in a car accident or whatever and needing a power of attorney earlier. And many of our friends and relatives and so on had that unfortunate instance. So power of attorney became very apparent to us, especially as we were looking after our own parents. So the point of this is that all of us are going to have different experiences, but communication is so important. I would suggest trying to make having or updating your wills a regular maintenance activity, much like many of the other things you do in your life. It's a maintenance activity, revisiting goals, revisiting things, moving, whatever, changing something. And it's just something you do in a regular process of things. If it's the first time you're doing this, try to simplify the process. Maybe use holograph and at least get things down on paper that are important to you. But I think if you make it inclusive and go slowly, I like Jimmy Pollard's analogies of taking time and taking, especially with a person dealing with HD, you're overloading them. So you need to, I find, introduce the topic gently on a good day when there's nothing else around and the TV's off and whatever, and let that topic sit. And revisit it a few days later and see if it's time to discuss it. And if not, then let it sit for a few more days and then come back eventually and sit and discuss and listen to concerns, lots of patience, more and more patience, and take notes and encourage your partner or the person you're dealing with on this to take notes, to write down their thoughts, and make a list of questions and concerns. And perhaps at that point suggest that you having a list and having some direction, that you might want to together schedule an appointment with a lawyer. And the key to this is, I think, to go slowly and not overload, and just do this as a matter of course if you can. And the fact that you're doing it, if you're not the Huntington's person, gives, I think, some credence to the whole process and how important it is for everybody, as Rebecca said earlier. So in our experience, making decisions about important issues requires plenty of discussion before any action is taken. And the discussion needs to be at a good time and not just dropped in and, as a kind of bomb on a person with HD who's trying to cope with other things, and all of a sudden you want answers or you want a discussion on this. There has to be some approach here that makes sense to them and that gives them some time to breathe and to process. Having said that, if you have a person who's already in need of power of attorney, I think there are ways of, just from my own personal experience, not with Ellen, but with someone else, of getting a lawyer and somebody in the hospital or whatever, care facility or somewhere else involved, and basically determine that that person is actually fit to designate you as a power of attorney, and that you can then help them out in terms of healthcare issues or other issues. So with that in mind, I welcome conversations if I can be of help, and I encourage you to make a will and, as they say, get your house in order. And I think these days, with the number of people having all sorts of things to deal with, that it makes sense to have financial or legal houses in order earlier. We know a lot more. So thanks so much. Rachel, over to you.
So thank you to Vern, Rebecca, and Zach in his pre-recorded video for starting the discussion today. We do have a few minutes here for questions, about 7 minutes, I would think. So we already have some from the audience in here, and I will just read them out and the appropriate person can answer. So the first one is for Rebecca. She asks, if I move from Ontario to Manitoba, should I transfer my will and documents to a lawyer in the new province where I'm living, or does it matter?
I mean, it just kind of depends. I would recommend making sure whoever you've named as executor and alternative executor knows where the will is. You can have it moved if you want. I know, like, when somebody locally dies, we often hear about it, and if the executor isn't aware of it, we'll let them know we have a will. So that's kind of the nice thing about having it local, but it doesn't particularly matter where it's stored.
Great, thank you. The next one here looks like it's for Vern. They ask, what do you think is the best way to start bringing up the topic of POA to a loved one? We are in the early stages.
I think personally, what worked for us was just to look around at our friends in our community and realize that somebody needed that. Maybe it was a person our age, a younger person, an older person, whatever, and that was something that we both felt we wanted to do. And we wanted to give direction, have somebody advocate for us or make decisions, and the process went for there. So I think gently, right, have the discussion, write some things down, and proceed from there.
Great. Looks like we have another one for Rebecca. They ask, can I prepare my own will, or do I need to see a lawyer?
Yeah, so I mean, the legal question is no, you do not need to see a lawyer to get a will. So there's a couple ways that wills can get made. First is a holographic will. So that one is one that's entirely in your own handwriting. You've signed it. That is a valid will. The second option is any other kind of written will, whether it's typewritten on a computer, in your own hand, can get witnessed, and that's also a will. And that's where you count things like will kits that you can get, at Staples or online will services. There's a lot of those now. Those are also valid wills. And then the third option is you go to a lawyer and you make a will that way. Now, what you're really paying for when you go to a lawyer is you're getting advice, right? You're getting legal advice that this is a will that's going to do what you want to do. But I know not everybody is going to be able to afford it, and it might be more accessible than you think. I'd encourage you to shop around a little bit if you're thinking about it. But if it's just not something you can afford right now, or maybe that's just not a conversation you're willing to have with a lawyer right now, I'd rather you get a will than not, right? So, write it down, have people witness it, use one of those online kits, do whatever it is that you need to do to get it done. My biggest piece of advice, if that's what you want to do, is the one thing people mess up the most with making their own wills is the signing. There's very specific rules on how it needs to be witnessed and signed. And basically, you have to make sure it's nobody that's benefiting from it or anybody's spouse that is witnessing it. So I'd encourage you to maybe consider going to a notary. They'll normally stamp it with something saying they didn't give you any advice, but they'll make sure it's actually signed and witnessed properly.
Great. And looks like we have a comment here from John. I'm not sure the scope of Rebecca's ability to answer this, but for people in BC, John is saying POA for personal care. BC has a representation agreement, which I think is the equivalent. So as Rebecca said, I think it's different in every province potentially, but I don't know if you want to add anything to that, Rebecca.
Sorry, so what are they saying about this representation?
Yeah, BC has representation agreement, which I think is equivalent, is what John said.
So I'm guessing that's sort of a medical care decision making. And so Ontario has something kind of similar that sometimes you're asked to sign in a hospital that'll sort of designate who's making decisions. Provinces also often have sort of a law, like Ontario's is the healthcare consent law, where if you haven't designated somebody, it basically allows sort of your next of kin to make decisions. Again, I would recommend doing it beforehand, do it early, right? Consider who knows your situation and who you actually want to make decisions. But it is sort of a nice backfall that, that does exist. It's better than nothing. That's what I would say.
Great. Okay, we have one here that I think we could have both of you answer from different perspectives. The question is about differentiating power of attorney between financial needs and medical needs. And the person is asking about their partner who does not want to give up as much control financially, but does want to have their partner be a POA for health decisions. Is there a way to differentiate that? And then on Vern's side, kind of how do you deal with those different conversations? Financial conversations, they say, are quite sensitive.
Yeah, I'll start if that's okay. So these are two different documents. So it's really easy. So the one is the power of attorney for personal care. That's the person that makes medical decisions. That's where you put in sort of any of your medical directives. And that one also does not apply until you're not able to make a decision. And to be clear, like that's not you couldn't make a decision one day and your capacity is better the next day. You go back to making your own decisions. They should be considering whether you are able to understand the treatment and consent or refuse it every time you are faced with a decision. It shouldn't just be the doctor says, well, this person didn't have capacity that one day, they're no longer able to make any decisions. So that's the medical side. The one for property, I talked about a continuing power of attorney for property, which is generally what people end up signing that is valid the moment you sign it. So somebody can use it even though you're clearly still able to make your own decisions. As I say, like people use it all the time if they're in another country and need someone to do something. But you can actually create a document. I'm trying to remember the proper term for it, but it's basically a power of attorney for property that's triggered. So you can have sort of a trigger situation. So you have to think about what would make sense as a trigger, right? Like who's actually making the decision there. But if you're not comfortable like giving away that power right now, is there a certain circumstance in which you would be willing to, like if a doctor wrote a note? But again, consider like how easy it's going to be to get a doctor to write that note.
Yeah, and I think Vern, from your perspective, just how you approach conversations about medical POA versus financial POA differently.
I think with medical POA, I've kind of outlined that. I haven't gone to the financial part because for me, most Huntington's patients are losing cognitive ability. They're not just losing physical or whatever, muscular or whatever, it's cognitive. So cognitive basically means in a lot of cases that over a period of time that in Ellen's case, for instance, my wife, that the math skills fade and the logic fades, and so looking after your financial matters, I think, is without a lot of checks and balances by someone else, I think is a little bit scary to me. And I would encourage that if someone's looking at a POA for health issues, that they actually consult their neurologist on their next issue and ask them about the cognitive issues. The next time they see the neurologist is probably testing them on that anyway. And if the cognitive issues are fading, then I would suggest to look after the funds that you've built that you care about, that you're going to need some, or you should have some help.
Yeah, and maybe it's helpful to think about you have options for who you name as well. Like you don't have to just name one person, right? You can name a couple of people and you can say they have to act together, right? If that's something you're worried about. I know sometimes people have concerns about giving it to one person. And an attorney is always required to account to the person that gave them that power. So they, can't just go and use the funds for whatever. They have to show that they've used the funds for your benefit. You still have a right to see what they're doing. You still have a right to revoke it. It's a lower test for whether you can grant or revoke a power of attorney than for various other things. So you might be totally able to grant one and, but, not able to do sort of the daily work of some of this accounting, right? So you can have layers there, right? There's lots of levels of protection that you can put in. If that's something like you're very worried about, again, it might be a situation where you want to hire a lawyer to get that advice.
That's a really good point.
Yeah, well, thank you so much. That's all the time we have for questions right now. If you have any further questions, I encourage you to reach out to Rebecca or Vern directly, and they might be able to help you out or point you in the right direction. And I just want to extend my thanks to Rebecca, Zach, and Vern for that very informative discussion and for the time they've taken with us today. Attendees, if you can stay with us for a couple of minutes, we are going to be handing out some of the community awards. It's always a wonderful recognition of community dedication and involvement. And after that, we will have a break, time to visit our exhibitor booths, and then the next session will begin at 4:15 Eastern time. So I'll go to that video now, and we will all see who has won one of HSC's volunteer awards this year.